The Supreme Court just heard oral arguments in a case that could change where every concealed carry permit holder in America is allowed to bring their firearm. And almost nobody is paying attention. Right now, in at least 5 states, if you walk into a grocery store, a restaurant, or a gas station with a legally permitted concealed weapon, you are committing a crime. Not because the business posted a sign saying no guns, not because you were causing a disturbance, but because the state decided that unless the property owner specifically invites you to carry, your gun is not welcome. That system is now in front of the Supreme Court, and based on what the justices said during oral arguments last month, it might not survive. The case is called Wolford v. Lopez. It was argued on January 20th, 2026. A decision is expected by late June. And what this court decides will directly affect how the Second Amendment functions in your daily life, in every state, starting this year. Before we get into it, if you are not subscribed, now is the time. This channel breaks down legal developments that directly impact your rights. I do the research so you do not have to. Subscribe and turn on notifications so you never miss a ruling that changes the game. After the Supreme Court's landmark Bruen decision in 2022, which struck down may issue concealed carry permits and said law-abiding citizens have a general right to carry firearms in public, several states scrambled to pass new restrictions. They could not deny permits anymore, so instead, they tried to make the permits functionally useless. Hawaii was one of those states. In 2023, the state passed a new set of gun laws in response to Bruen. One of those laws created what gun rights activists call the vampire rule. The nickname comes from vampire mythology, where a vampire cannot enter your home unless explicitly invited in. Hawaii applied that same logic to firearms. Under the law, if you hold a valid concealed carry permit in Hawaii, you cannot bring your firearm onto any private property open to the public, unless the property owner has given you express permission. That means stores, restaurants, gas stations, malls, parking lots. All of it is off limits by default, unless the owner specifically says guns are welcome through a sign, a verbal statement, or written authorization. Think about what that means practically. You have a legal permit. You passed the background check. You completed the training. And you still cannot carry in almost any building you would actually go to in a normal day. The permit exists, but the places you can use it barely do. 3 Maui residents, Jason Wolford, Allison Wolford, and Adam Kasperzicki, along with the Hawaii Firearms Coalition, filed a lawsuit. They argued that this law takes the right the Supreme Court recognized in Bruen, the general right to carry in public for self-defense, and guts it. If you cannot carry in a grocery store, a restaurant, or a gas station without prior permission from the owner, what does a carry permit actually give you? The right to carry on the sidewalk? A federal district court in Hawaii initially blocked the law, siding with the gun owners. But the Ninth Circuit Court of Appeals reversed that decision in September 2024. A 3-judge panel upheld Hawaii's vampire rule, finding that the Second Amendment did not require private property owners to allow firearms on their premises. The panel ruled that the history and tradition of American firearm law supported the idea that property owners have the right to exclude guns. The Ninth Circuit denied a rehearing, despite 8 judges dissenting. The plaintiffs petitioned the Supreme Court. On October 3, 2025, the court agreed to hear the case. Here is the specific question. Can a state prohibit licensed concealed carry holders from bringing firearms onto private property, open to the public, unless the property owner gives express authorization? Or, put more simply, what is the default? Are guns allowed on private property open to the public, unless the owner says no? Or are guns banned unless the owner says yes? That default is everything. It determines whether your carry permit functions in the real world, or only on paper. The Supreme Court heard arguments on January 20th, 2026. The court appeared divided, but several conservative justices pushed hard against Hawaii's position. Alan Beck, the attorney for the gun owners, argued that Hawaii's law has no legitimate historical support. He specifically challenged the two historical statutes the Ninth Circuit relied on. One was an 1865 Louisiana law that banned carrying firearms on private plantations without the owner's permission. Beck argued that law applied to private land not open to the public, making it a poor comparison. He also pointed out that it was enacted as part of Louisiana's Black Codes, laws designed to strip rights from newly freed Black Americans after the Civil War. Justice Gorsuch picked up on that point directly. He asked whether the court should be relying on Black Codes to define the nation's historical traditions around firearms. The implication was clear. If your best historical analogy for a modern gun law is a racist post-Civil War statute designed to disarm Black citizens, that is a problem. Chief Justice John Roberts raised a First Amendment comparison. He pointed out that a gas station on the side of a highway is private property, but people assume they can enter without express permission. He asked whether, under the First Amendment, people have a recognized right to go door to door distributing pamphlets on private property. The answer is yes. So why would guns be treated differently when the Constitution also explicitly protects them? On the other side, Neil Katyal, representing Hawaii, argued that there is no constitutional right to assume that an invitation to shop includes an invitation to carry a firearm. He stated directly that an invitation to enter a store is not an invitation to bring your Glock. He pointed out that Hawaii has issued over 2,200 concealed carry permits since Bruen, and argued the law does not burden gun owners. Justice Sotomayor questioned whether Hawaii's local culture creates a different expectation around firearms than other states. Beck rejected that framing, arguing that because Hawaii is part of the United States, the national tradition of carrying on private property open to the public should apply. Justice Barrett appeared surprised when the challengers argued that the Second Amendment technically protects a right to carry a firearm into someone else's private home. That moment illustrated just how far the legal logic could extend. Hawaii is not the only state with a law like this. After Bruen, California, Maryland, New York, and New Jersey all passed similar restrictions. These states could not deny permits anymore, so they tried to limit where permits could be used instead. All of those laws are potentially affected by whatever the Supreme Court decides here. If the court strikes down Hawaii's vampire rule, it would establish a national default. Concealed carry permit holders would be allowed to bring firearms onto private property open to the public, unless the property owner explicitly prohibits it. That would flip the script in every state that currently operates under the opposite presumption. Business owners who want gun-free premises would need to post signage or otherwise communicate their preference. If the court upholds Hawaii's law, states would retain the power to set whatever default they choose. Some states could require express permission to carry. Others could allow it by default. The regulatory landscape would remain a patchwork. Legal analysts watching the oral arguments believe the court is likely to strike down Hawaii's law. The conservative majority appeared skeptical of the historical evidence Hawaii presented, and the comparison to Black Codes created a serious credibility problem for the state's argument. But nothing is decided until the opinion drops. This case does not exist in isolation. There is a second major Second Amendment case this term, United States v. Himani, which the court will hear arguments on March the 2nd. asks whether the federal government can ban firearm possession for marijuana users. The Fifth Circuit struck down that ban, and the NRA, the Cato Institute, and NORML all filed briefs supporting the gun owner. That case, combined with Wolford, means this Supreme Court term could produce two of the most significant gun rights decisions since Bruen itself. And beyond this term, assault weapon bans, magazine capacity limits, and red flag laws are all working their way through the courts under the Bruen framework. Justice Kavanaugh has publicly stated that the court will likely take up the AR-15 question in the next term or two. The legal trajectory is unmistakable. In 2008, the court said you have the right to own a gun at home. In 2010, they said that right applies to state and local governments. In 2022, they said that right extends into public spaces. Now, in 2026, they are being asked whether that right follows you into the places where Americans actually spend their time. Each case builds on the last one. The right keeps expanding. First, know your state's current law. Even if this decision goes the way gun rights advocates expect, the ruling will not drop until late June. Between now and then, your state's existing carry restrictions are enforceable. You can still be arrested for violating them. Do not assume the case is decided before it is. Second, if you have a concealed carry permit, understand where you can and cannot legally carry today. Check for posted signage. Know which locations your state designates as sensitive places. The rules are different everywhere, and ignorance is not a legal defense. Third, stay informed. This decision will reshape concealed carry law across the country. When it drops, you need to know what changed and what did not, because the difference could keep you on the right side of the law. Quick legal note. This is educational information. This is not legal advice. I am not your lawyer. Gun laws vary by state and by county. For your specific situation, consult a qualified attorney in your jurisdiction. If this video helped you understand what is coming, hit that like button and share it with someone who carries. Subscribe if you have not already. I cover every major legal development that affects your Second Amendment rights, and this term is going to be one of the biggest in modern history. Drop a comment and tell me, does your state have a vampire rule? Can you carry in a grocery store right now? I read every comment, and I want to hear where you stand. Stay safe. Stay legal. Stay informed.